In February 2020, both I, the Working Group on Arbitrary Detention, the Working Group on Enforced and Involuntary Disappearances, and a number of other special rapporteurs issued our deep concerns about the adoption of the Terrorist Entities Law and the Anti-Terrorism Law, both of whom also have a web of relationship with a number of other legislative enactments, including the law that regulates peaceful demonstration, as well as the law on associations in Egypt. And one of the things I would stress from a regulatory point of view is just how enmeshed and dense the security law system is, and how difficult as a result it is to ensure remedy and access to protection for human rights defenders as a result. In respect of those laws, I do want to stress the key points that my mandate and others have communicated to the government. The first is that we are deeply concerned that the definition of terrorism and the definition of extremism in national law is overly vague, it is imprecise, and the result of that is that it leaves open the possibility for systematic abuse of the law and its use against ordinary citizens, journalists, and NGOs. The second thing I would stress is that we have been really highly concerned that the use of these laws has a huge overlap with a number of other fundamental human rights violations. And there, I particularly want to stress the challenges of enforced disappearances. And in particular, one of the major concerns I have is that the anti-terrorism law effectively codifies enforced disappearances by allowing individuals to be arrested and held for up to 7 days incommunicado before they can be questioned by a prosecutor.